Well, it is time now for our expert insight and analysis on the Murdaugh double murder trial. Joining us, trial attorney Carl B. Grant. Billy, it has been a day of really, I guess, technical testimony, Carl.
Yes.
That it's not has been as exciting as for the people, the commentators who've been watching, but important testimony nonetheless, right?
Yes, absolutely. The testimony, of course, is primarily outside of the juror's presence about the financial transaction crimes, and still laying that foundation, still for the judge to consider whether he's going to allow that in to prove motive. Very important testimony for the prosecution, considering what they promised to the jury in their opening statement.
And Carl, why do you think the judge has not ruled on admitting that financial transaction, the alleged crimes, into evidence as a motive yet?
Because the judge is still, let me tell you something about the judge. He's one of the best trial judges this state has ever had. Judge Newman is smart, and he's respected by bench and bar, and you see he has a soft voice, but he's definitely respected in the courtroom. He's a man who, he doesn't play around. And this stage is not too big for him. So what he's doing now is he's taking his time, because naturally he realizes that the prosecution does not have the right to appeal. If this man is acquitted, that's it for them. They can't try him again. So he needs to make sure that he's even-handed, consider all the evidence that the prosecution wants to proffer and consider, for him to consider, and then make a decision as to whether or not he's going to allow it to come in.
I want to talk a little bit about the ballistics evidence that we've seen today. We'll get to that in just a moment, but I think the foundation for this conversation is the fact that there's no confession, at least not a direct confession. There's some statements that have been made that some interpret as possibly a confession, but there's no direct murder weapon found. There's been a lot of indirect evidence to try and connect weapons on the property and identify some similarities. But how difficult is it for the prosecution to gain a conviction in those circumstances?
It clearly makes the prosecution's case more difficult, but people are convicted every day of the week without a murder weapon and without a confession. And on the other hand, people are acquitted every day of the week for those same reasons. So in this case, the jury will just have to decide what is the evidence and how strong is the prosecution's case. But yes, it can go either way when it comes to lack of a murder weapon or lack of a confession.
And Carl, I want to go back to something that we didn't get to discuss yesterday because of the financial alleged crimes. That Snapchat video that was released a few days ago showing Paul Murdaugh Snapchatting his dad in different clothing. And according to the prosecution, this was taken earlier in the day of the murders. But of course, when we saw Alex Murdaugh with officers, he had on a totally different outfit. So how could this play for the defense and the prosecution at this point?
Well, for the prosecution, that's probably the strongest evidence. The two Snapchat videos, number one, with him wearing long pants and a shirt with short sleeve shirt, totally different clothing, 1 hour before the time of the killings. And then, of course, the other Snapchat video, approximately 4 to 5 minutes, with the voice being recognized as being there. Comparing that to what he said, that he was sleeping at home and not even at the dog kennel. So that's the prosecution's strongest point. Now, for the defense, we haven't heard the defense yet. Are they going to come up with some plausible explanation for that evidence? Will they have some experts, some technical experts to explain this away? Who knows what they may have, but we have to wait and see. And that's why you always tell the jury in your opening statement, please keep an open mind. These people may start off with a snowball of evidence, then it becomes an avalanche, and we can't even get to present a single witness or establish our defense until the prosecution is finished.
We heard some testimony on the stand today from a ballistics expert talking about some of the shell casings that were found on the property and how he believes there's some similarities there. And the defense obviously tried to challenge him, but he withstood that scrutiny, basically saying that this is science that has been around for a long time and is widely accepted. What's your assessment of how important that testimony is?
That's very important testimony, but of course the jury have to weigh it all and determine the credibility of this expert's opinions, because an expert witness doesn't really get any more value as a witness than a layperson. A jury can discount or even totally disregard their testimony if they want to. So it's all going to go to the value that the jury places on the testimony, and that's why it's always good to have a good cross-examination of the witness regardless of what they're saying.
And Carl, at this point, some may argue that the defense is creating that reasonable doubt, while others are saying that the prosecution has a strong case. Now, if it gets to the point where there is a hung jury, where the jury feels like they're confused and they can't decide on one outcome, What does that mean for Alex Murdaugh? I mean, can this case be tried again?
Well, it's a bit early to talk about hung juries, and I know that's a lot of that's going on in the blogs and with the public commentary and everything, but the defense has not even put up its case, and of course the prosecution not even finished with their case yet. But to answer your question, if there is a hung jury, the prosecution can try the defendant again if they so desire. Now, of course, if he's acquitted, that's the end of it because of the rule of double jeopardy, but they could try him again if they wanted to.
You talked earlier about Judge Newman and his reputation does precede him. What's your assessment about the demeanor in the courtroom, how even-handed he has been in terms of hearing the motions from the prosecution and the defense?
He's been absolutely perfect in the capacity as a judge. He has shown that he is fair-minded, and he is a judicial officer who's doing exactly what he's supposed to be: neutral, impartial, and detached.
And it's given the jury some breaks to stand up and relax as well.
Yeah.
And I'm sure they like that.
Appreciate that.
Yes.
Yeah.
What do you expect going forward, Carl? Because I know at this point the jury has rested, or the arguments have rested for the day. The jury will return 11:30 on Monday. I mean, how long could we see this back and forth about the financial evidence and whether or not it should be admitted?
Well, that's up to the judge, of course. I think when he gets to a point where he can make a ruling, there's been enough evidence presented where he feels he has sufficient information to make a decision as to whether or not this evidence rises to the amount of establishing a motive to commit these heinous crimes or not. And once he gets to that point, I imagine he will make a decision.
So the jury has a break for the weekend. I'm sure the attorneys will be working through the weekend trying to tighten up their cases. The blogs and the Twitterverse will be busy speculating as well. From your expert analysis, your opinion, what are the key things that we need to look for in this trial next week?
Well, you need to look for what evidence more will the prosecution be allowed to use? Will they be able to use this motive evidence that they want to use? And if so, how much will they be allowed to use? If the judge decides to let them use some, I cannot see him allowing him to use all of it, because the last thing the court wants to do is to have what you described the other day as a mini trial within the trial itself. So I can see, I'm not trying to predict anything here, but I can see a probability just based upon experience that the judge might allow some evidence, but not allow all of the evidence to come in on the financial crimes.
Okay.
And we talked about that crescendo moment, right, for prosecution with the Snapchat video. Do you believe there would be a crescendo moment for the defense at this point?
Yes, but again, we haven't heard anything. That's the thing about having to be so silent. You can't even start your case until they're finished theirs. But here's the thing about cross-examination. The most effective thing in cross-examination is to turn one of their witnesses into your witness and to beat them with their own case. Now, when you're doing that, when the prosecution is presenting their case, and now you have people thinking that you're winning when you haven't even put up a single witness, that's a good day for the defense.
All right, well, we'll see if that day comes because it's been a challenging week for them, but this trial is not over. Trial attorney Carl B. Grant, we appreciate your expertise and your insight and wearing red today for Wear Red Day and Heart Awareness Month this month.
Thank you.
All right, thank you so much.
All right, we'll hear back from Carl on Monday. Make sure you stay tuned right here on WIS at 5:30 for our continued trial analysis. For now, we're going to take a break. We'll be right back.